Well, thank you very much. This is Exotic Park, and I'm going to introduce the Institute. Well, and that's one of the problems because it's an Argentinian talking about rule of law in Argentina, and this is the Max Planck Institute for European Legal History. So where is Argentina? The thing was that when the Max Planck Institute was founded in 1964, actually the name of the magazine was Ius Commune. The intention was to build the basics of the whole European community. So it was an attempt to show the roots of law that reunites the whole countries. After that, in 2001, we can see Rechtsgeschichte. This is the new Zeitschrift, and there you can find that it changed. It's not only European legal history, but contemporary legal history, police studies, and they opened and extended the frontiers of science towards Latin America. And in 2014, Global Perspectives in Legal History, this is a new series of books that is being published for the Max Planck Institute, which reunites the global perspective of law, because we understand right now that law is not only created in Europe and translated into Latin America or other places, but it's always an interaction between different legal spaces. So most of the topics that we are right now working is not only law in the state meaning of law, like what is provided, but multinormativity, which involves process of translation, that it's also Rechtsräume as legal spaces, how law also create different space. It's not only geographically, law is very important, and also conflict regulieren, which is like the regulation of conflicts, which is not only provided by the state law. What I'm going to try right now is to show how the concept of Rechtsstaat, this German word, came to Argentina, and mostly the different meaning that this concept has in Argentina. So I'm going to work with different Quellen, like these sources of law, and also is a part of the Rechtsgeschichte Iberoamerica's, and also it has to do with how jurists act in front of different concepts. So I'm going to, well, so this is the three things: concepts, process of reception, and the political and juridical uses of concepts, methods and juridical thinking, legal principles, which is one of the topics, and then the connection between Latin America and German conceptuality. Now, the thing is that I don't want to translate Estado de Derecho of rule of law, because as we are going to, trying to show, it's quite different, the symbolic meaning of Estado de Derecho in Argentina in comparison with rule of law from the American or the German translation. Now, before, and that is one of the problems. Since the 18th centuries, the legal system has been inspired in providing stability, precision, security to society. From there, key concepts such as legal security, Rechtssicherheit, rule of law, Rechtsstaat, or constitutional guarantees, Grundrechte, exhibit the interest in modern law in providing a tool for a reasonable prognosis of social expectation. As an example, we can see law, the important role of law, because in a way it's in charge of protecting the research, development, and the creation that have been spoken here. For instance, intellectual property, copyright, and so on. So this is something that everyone is worried about. But in the last decades, there are some conceptual problems within the juridical field, because there is this double process of internationalization and transnationalization of law, which, if in the national states the discussions were abundant, in this process of transnationalization, it's changed from state law to legal principles in order to transcend the frontiers between countries. What we are not now going to do is to make some example on the concept of rule of law, which implicates several translations: Rechtsstaat, Estado de Derecho, Estado de Direito, Estado de Direito, État de droit. Every country has the use, and the meaning is different because of the historical experiences. Well, some general remarks on rule of law, or whatever are your countries, what is translated by your jurists. Oh, sorry. Well, Okay, at the present, the concept of rule of law is ubiquitous in political and legal discourses. In the political field, the positive emotional character of the word implies that its mere invocation blocks the possibility of criticism. No one would be against the rule of law, and everybody claims to be its defenders. This generates a regime of immunity of the concept that explains the inflationary use of it. However, very little is known about its content and meaning. It functions only as a rhetorical figure to provide substance to discourses. Everyone in every country are listening to, everyone is defending the rule of law, and everyone is defending by attacking the other one, but no one knows what the meaning is. So, but then we have the juridical use. From the legal point of view, the concept has a dual function. It is a guiding principle that organizes desired horizons of expectations. It is a concept for struggle for a better democracy, for defense of human rights, respect for the Constitution. But also, law always needs the stabilization of concepts. So, between the legal understanding, common law has been defined by 5 elements. Government of the law and not of men. In German is Herrschaft des Gesetzes. Separation of power, legality of the administration, judicial control of administration, and then the effective guarantee of fundamental rights and freedom. Now, if we cross the two, it's like the constitutional theory and rhetoric, we have some problems. And I'm going to show a case in Argentina. This case was about a crisis that happened in 2017 when the Supreme Court of Argentina decided an appeal filed by Luis Muña, who was accused of crimes against humanity committed during the last dictatorship. In this case, the Supreme Court said that because of the Estado de Derecho, the principle, it should be free, because they cannot separate between crimes committed against humanity and simple crimes. So the problem was that the very use of Estado de Derecho was a little bit suspicious in that case. This day after, the press, this is the most important Argentinian newspaper, wrote this article called El Estado de Derecho, the rule of law, by saying that if we want to respect the rule of law, we should give equal treatment to repressors that participate in the last dictatorship. The problem was that all of a sudden, there was a huge manifestation in the Plaza de Mayo because everyone, or most of the people said, we cannot not punish this man. The very same day, the Senate approved a law that said crimes against humanity, we cannot apply the same rule as the same problem. But the thing is, what happened in Argentinian constitutional culture? Why is not the rule of law only the separation of power and the rule of law and the government of law? The problem is that we should go to history. In Argentina, the concept of rule of law was received in the 30s. It was a translation of the Rechtsstaat, which was discussed at that time by Carl Schmitt, Hermann Heller, and other authors. However, its use was rather secondary, mainly because it was not consistent with the traditional grammar of Argentinian constitutionalism, which was closer to Hispanic and North American concepts. Only around 1983, the term was widely used by jurists and politicians. The concept was used at that time of the democratic recovery with the aim of prosecuting the juntas militares and defending human rights. In Argentina, the concept of Estado de Derecho was forged as a tool of legal struggle through a counter-conceptual opposition to the figure of terrorismo de Estado, state terrorism. As we can see, as this picture shows, it can be observed how those who had the power of life and death over large parts of the population were subjected to a trial with legal guarantees and democratic judges. The intellectuals of that time and the jurists discursively unified the defense of Estado de Derecho with the idea of the need of stable democracy. As you can see, it works as a counter-concept. Terrorism, state terrorism was there. These were the juntas militares, and there the rule of law, or the Estado de Derecho, was there, were all these people that were the judges of the democracy. Now, the thing is that the change of emotional sense inscribed in the concept was built as an opposition to the image of the violation of human rights. Even the word desaparecidos, the verschwunden, was not translated in different languages. The dictatorship and state terrorism were in this traumatic event that justified the creation of Estado de Derecho. So, what defines Estado de Derecho in Argentina is not only the guarantee towards law, but also the defense of human rights. And the idea of human rights that we have in our mind is always connected to the last dictatorship. For example, during the rules of the judgments of the Supreme Court, during 1980s and 2010, the concept was only used when the cases were against people that committed crimes against humanity. There was not other use. Now, there is also another problem there. So the context of enunciation, or the context of reception, was in the tension between dictatorship and democracy. But then there was this counter-concept, state terrorism against Estado de Derecho. But then there is a temporalization and the imaginary of arbitrariness. And this last part is that in Argentina, the Estado de Derecho was linked to a book called Nunca Más, Nevermore. It means that the rule of law established that we never can go back to the military dictatorship. So there is a temporalization that is always looking for a better democracy, better quality of institution, and never have a dictatorship again. So as we can see, there is an emotional bound to this concept in Argentinian constitutionalism. Now, however, since 2015, the concept has started to be eroded. It has begun to indicate that it is necessary to defend the Estado de Derecho from a possible populist future state. So the regime of temporality is changing. It's not looking toward the past, towards the future, against the past, but right now it's defending from what could happen in the future. So it has lost the sense of Zielbegriff, and this character is taking more and more a conservative tone to the state action. Actually, Michael Stolais, who was one of the directors of the Max Planck, told me that right now in China, in order to justify several actions, they say we are doing that in order to protect the rule of law of China. So, in this field, the legal dogmatics require history, and history needs to think about law with greater conceptual precision. Now, this is what is going on right now. After this case, what we can see is that the denationalization, destatization, and the internationalization of law cannot build boundaries between cultural experiences. In fact, the question would be, what is the concept of rule of law that you use? Or what is the traumatic experience that justifies the motiveness of this concept? I don't know, in Germany, or in Colombia, or in Argentina, or in Uruguay, the concept could be the same, could be legally justified the same way, but at the same time, what it's opposed to as an arbitrariness is different. Now, that's why we need a cultural approach to the legal phenomena. Sociology, anthropology, history, cultural studies are right now taking a lot of impact on legal theory. Now, the last part is legal system as a world of normativities. This is multi-normativity. In fact, if the nunca más is not a norm, it should be considered as a justifier for using this principle in Argentina. And then the resolution of conflicts in a complex world lead us to law and diversity as a problem. We cannot use all the same concept, and sometimes we should agree on what is the meaning of the concept without annihilating the different social experiences that present some principles of law, such as the rule of law. Thank you very much.